Good morning, everyone. Welcome to our new session on Saturday webinar on key amendments to SEBI listing regulation 2015. Friends, this is the first webinar on the topic in India, and I can see the participation. And I must say that this webinar instigation I got from Alifya presenter only. We were going to Visakhapatnam, and on the flight only she was telling, ma'am, yesterday night all this come, this will happen, that is happen. I said, oh, too much is there. Let's have webinar next Saturday. I told you only prepare the PPT and prepare and present. So this way we carried out, and then I have to search the person who must have studied so fast, and who else can afford than Amita. And she was kind enough with her busy schedule also. She said, okay, Dipti, since this is a fresh topic, I will surely love to be participating. And she agreed to be panelist. Thanks, Amita. And then we are fortunate today also, Miss Varika is also agreed to join. And she is also there with us. Thanks, Miss Varika, for your time and contribution. Thanks a lot. Friends, today we are happy as this program will be more on a discussion part because there are many confusion, ambiguity, and all our participants do actually participate because all our participants are also equal to us. As usual, we say it's a discussion forum and nothing one-sided. Okay, let me introduce formally. Of course, we have with us Mr. Sudhakar, our own. I don't need his, he need any introduction, and Mr. Bala also, as usual, our all-rounder. So let me introduce formally to Ms. Varika. Ms. Varika Rastogi is a fellow member of ICSI and holds bachelor degree in law from Meerut University. She has versatile experience of more than 2 decades, oh great, in the field of corporate law, company secretary, global compliances. Presently, she is heading the corporate secretarial, legal and global compliance function for 3A Infotech Ltd. She is a member of executive leadership team of 3A Infotech. Corporate governance and strong compliance-driven organization culture is a focus area for her. Her work experience includes a stint with renowned corporates such as Majesco Limited, Chambal Fertilizers, that is KK Birla Group, Hero Honda, Modi Group, etc. She is passionate about philanthropic activities and supports various NGOs engaged in healthcare, education, and nourishment of needy children. Welcome, Ms. Varika. Thanks for your time.
Thank you so much, Dipti. And welcome all.
Yeah.
Now, let me formally introduce Amita Desai. Everyone knows her, but it's my duty. Amita Desai is a practicing company secretary with 27 plus years of experience. My dear friends, today we have so much experience added in this panel. In the field of corporate compliance and governance, she is an insolvency professional and CSR consultant. She is a founder of Amita Desai and Company firm based at Mumbai, which provide advisory and secretarial services on the Companies Act, FEMA, securities law, IBC, merger and acquisition and restructuring and CSR. She is also advising on governance and compliance to many NGOs. She is a regular speaker at various forums of ICSI, ICAI, and other social enterprises. She has contributed various articles which are published in Charter Secretary, Focus magazine of WRC Mumbai, and E-magazine of Mysore chapter. She is a trainer, motivator, and arbitrator. She loves traveling and interacting with people on issues related to governance. Welcome, Amita. Thanks a lot for your time.
Thank you, Dipti.
Okay, thank you, Amita Ben. No, in a short notice, you accepted. It was something great. Thank you.
Yeah, she was too busy, but she accepted. Thank you, and thank you, Varika, also. Also, I'll request Miss Amita and Miss Varika to say a few words on the topic, and then Mr. Bala, and then Mr. Sudhakar, and then Mr. Bala to say a few words on the topic, and Alifya, then you can start. Over to Miss Amita and then Miss Varika.
Yeah, thank you, Dipti, and good morning, everyone. It's a very new topic and not I mean, there are a lot of changes under LODR, and this is a substantial amendment after the consultation paper which was been given. Many points are accepted by the government, and I think for the company secretary in practice, there are a lot of additional work for the quarter going onward with reference to various disclosure requirements. Major amendment are under Regulation 30, where there is a material disclosure requirements are there. Then the annual report where BRSR, which is applicable for top 1,000 companies, and of course, rumors, which we will discuss in detail about how to at least reply, deny, or clarify. That's a major amendment. With the cyber security again, but one more relevant and in alignment with the global standard. I think after digitization, the cyber security and incident happening in the company should be reported to the stock exchanges, which SEBI has understood, and I think that's very relevant for all companies. And they have to gear up with the resources to be deployed for such security reporting. Various mainstream definition also has been changed to mainstream media. So those are the changes we will discuss, and we have a stalwart like Sudhakar ji and Bala sir also, who can always share their experience, how the company should be able to gear up with the compliance part. And thanks for inviting Dipti once again. Over to Varika, sorry. Thank you. My apology, I can start my video, otherwise I would have enjoyed. Thanks a lot.
Yeah.
Anyway, today we are seeing you invisible. Huh? Mr. India. Mrs. India, we can come.
Yeah, Ms. Varika.
As Amita has elaborated, from a corporate India perspective, these changes are arduous. These changes are very arduous, I feel so, and a corporate CS has to gear up to implement those challenges and to make the organization aware, so that a company secretary can be able to ensure the compliances with such a adverse, and a corporate CS has to read those amendments with a very fine tooth and analytical mind, and how you can ensure the compliance while amending your policies, materiality policy and the other policy, and to sensitize the stakeholders amongst the organization. Because whenever any changes are brought in by the SEBI or any other regulatory authority, to ensure the compliance and to make it has to be a collaborative effort among the team members of your organization, from your finance team, from your marketing team, who are dealing with a lot of information. So that would be a key part when the collaboration comes into place. So let's move on to the agenda of the day.
Thank you. Thank you, Ms. Varika.
Thank you, Dipti. And thank you, Mr. Atul, also for giving me this opportunity. And yeah.
Thanks. Mr. Sudhakar, please.
Yeah, good morning, everyone. Delighted to see that almost we have crossed the 275 mark, and I think this is the first time. And friends, in fact, there is a saying that in life, what is the certainty is nothing but death is the certainty. But in case of a professional's life, it seems to be the amendments are the only certainty. And whenever the amendments are taking place, right from the Companies Act 2014 or the Listing Regulations 2015, these amendments are not small, full stop or comma here and there. They're completely rehashing the things, and sometimes they're adding so many new things. And if you see today's amendments, both are there. They have rehashed the provisions, they have substituted the provisions, but very sparingly they have deleted anything. Only they have added many things. Definitely, these amendments are going to put the professionals, especially who are in service, into a lot of hardships until they understand that properly, first of all. And after that, they have to also create the awareness across the organization, especially in case of Regulation 30, the kind of disclosures what are expected. That kind of an awareness is to be necessarily there. As Amita has rightly mentioned, it has also enhanced the scope of work for the practicing company secretaries. So irrespective of the matter, whether you are in practice or whether you are in service, you need to have to understand the nuances of these amendments thoroughly. And this is our first attempt towards this. And let me also say on behalf of the other co-panelists as well as on behalf of the firm that this is hardly 1 week old, and whatever we are discussing today, to the best of our understanding of the amendments, maybe in the coming days, we may get more maturity on this and more clarity on these things. But yes, no doubt about it. In fact, when we were initiating today's webinar, myself and Dipti, we were discussing whether to have it or not to have it. But we thought that let us set the ball rolling. And after that, whatever the clarity required, further clarifications required, we will get it over a period of time. To start with, let us have today's program. Thanks. Over to Bala to you. Thank you.
Good morning to all of you. I am really, really overwhelmed to see the response at the beginning of the seminar itself. Goes up to 300 people. That shows the importance of this particular topic. There's a sea change of amendment has been brought in by the SEBI. And this is not only going to be involved interpretation issues, because there are words, many places which is actually used unless. So really, whether it denotes pre-approval, post-approval, etc., those sort of things are going to be there. Again, they are interested in tightening the compliance requirement and the smooth functioning of the organization. Perhaps that is the reason why, as against the casual vacancy filling of 6 months, now all the KMP's vacancies have to be filled within 3 months. That sort of the amendment has actually come up. And again, there is an amendment regarding the people's holding the position 75 years, especially promoter group, etc. Again, they'll have to go to the shareholders, get it ratified, all those things which has actually come. Really speaking, as other panelists said here, it is going to be very, very, difficult for the company secretary to understand, analyze, and take his action. There are a lot of actions are emanating from here. Because he being a compliance officer, he has to get many things from the other departments, in which case what is going to happen is he has to bring the awareness within the organization, even in the promoter group, etc., which is affecting, where the company is not the party to the agreement, but where the KMP's other directors are party to the agreement, even that has also been brought under the net, in which case getting the information, getting the awareness, making them people know what is required to be done is going to be a lot of a marathon job for a company secretary. And various actions are emanating from here, because now probably the amendments have come in such a time. This is the quarter which is actually supposed to have the board meeting for many companies by June ending. So in which cases, wherever the action which is calling for, some of the companies may be able to take the approval from the board if necessary. Where they are not able to take it or something, they'll have to find out the way. But the earliest thing is wherever the approval is required, it is called for. Because disclosure, posting it on a website, various amendments, a lot of things are going to be there. Added with that, again, in the practice, scope of the practice actually getting enhanced to the greater extent. It is one side, we are talking about the ease of doing the business, but the other side, the compliance is getting more and more complicated. We need to gear up to that. As Dipti actually said, this is the first webinar which has come within a week of this amendment which has actually come. There will be more hiccups when we start implementing it. There will be more clarification will be sought. There will be doubts will be arisen. Interpretation loss will be there. All those things is there. As rightly said, today being the first webinar, we will try our level best to give our thoughts, our interpretation, etc. As we go along, more clarification also we can expect. I think with this, I will ask your presenter to proceed.
Thanks, Mr. Bala. Alifya, you can start. Dear participants, this topic, there will be a lot of questions. So please put your questions in chat box. The same will be taken along with the slides. And there will be no question answer session today because the presentation is too long and discussion will be there. Thanks a lot. Your active participation is highly appreciated. Yeah, Alifya, start please.
Yes,
respected panelists and my dear professional colleagues. I'm audible?
Yes, sir, very much.
Yeah.
Thank you. I, on behalf of Mehta and Mehta, welcome you all to this webinar on key amendments to listing regulations. As we all are aware, SEBI has notified SEBI LODR Second Amendment Regulations 2023 on 14th of June. These amendments are the results of various consultation papers issued by SEBI from time to time. Some of the amendments have immediate effect, whereas others would come into force from the 30th day of this notification, with effect from 13th July. Let me take you all through all these amendments. So we begin with a new definition that has been inserted by SEBI. By this amendment, it defines mainstream media. Here, the mainstream media has been defined to include print or electronic mode of the newspapers, news channels, content published by the publisher. So this amendment has been specifically brought about for the disclosure of material events which are leaked in the mainstream media before it is disseminated by the listed entity.
Any comment by panelists? Alifya, go to the first one.
See now, so all these media agency also have to register with SEBI. Does it mean like this?
No. Register.
No, Atul. Newspaper are registered.
Okay.
Newspaper entities, media entities are registered. Only those, if they are giving any kind of news about any listed entity, that has to be clarified or denied or confirmed, whatever it has to be.
Only I have my comment as regards, I don't know, is that a requirement for media that before they publish, they should compulsorily seek some clarification from the company for which they are writing?
No, they are not required.
I don't think
exactly. So. I was also of that opinion, but still I want to confirm. If that kind of thing, because exactly in analysis written that how you know that which media, what is going on, you can't keep a track on everything. So if there is this kind of requirement is there at least, this is my personal thinking, then it helps in two ways. The company also know and at least some responsibility on the company, on the media. I don't know. You panelists, your views.
Dipti, it is like this, that say the rumors are to be denied and rumors are to be clarified, okay, by the listed entities. Now the question comes is that when you talk about media, the social media is so wide, where all it is getting published, how a company can keep track of that.
Exactly.
So for that particular purpose, that SEBI has defined mainstream media. So what is a mainstream media? That is newspapers and news channels and other what's called the electronic media or whatever it is and all. So we are confined only to the rumors or news items or whatever they are getting published in these, whatever is coming in the definition. Other than that, we don't need to worry about it, whether it is the WhatsApp messages, LinkedIn messages, or your OTP platforms or whatever are there. We don't need to go everywhere here and there. Only thing is what the company secretary of the listed entity has to do is by whether anything is there in this mainstream media, yes, the company has to revert to that, otherwise not required.
But
this is a great help according to me to the industry.
Because, of course, this clarification is helpful. But again, this is also difficult according to me for a company secretary or kind of thing.
But of course, you see, most of the times what happens is bigger companies, they do have communication departments, and of course, they will take care of that. And
it is tough.
Say, for example, a company of Reliance, that we used to have that communication department separately. And so we used to be in alignment with our communication department, and they used to feed us with that, whatever is coming and all that.
Already someone is asking, how can a company check whether the computer digital publication is registered or regulated or not? That is number one. Number two, there is another, somebody is also asking, what do you call?
It is...
So will social financial site like a money control also included?
No, to narrate it's simply all the questions. Many are asking whether Twitter is there, whether mainstream media, how can you track, then social financial site like money control included or not. And again, someone, Ankur, has mentioned that it is an inclusive definition. So it should include other media also. Just clarify.
With reference to this media, I believe there are the separate resources to be built, to be deployed by every company to find out to find out where the media
now
is getting published.
I was coming to that point only. It is you have to deploy the resources.
Exactly.
Otherwise, it is not possible. Now, Mr. Raja, there are 70,000 newspaper and 5,000 news channel. How to train them for news by KMP?
And my view is also there that if you go further in Regulation 30 by option also, if your director or KMP or any of the employees are giving any statement or any chat or any put on the social media, suppose somebody is tweeting or he has put something on tweet, company has to immediately disclose to the stock exchange, and that you have to sensitize your internal all KMP directors and promoters, or it goes further to the employees also. So that's a challenging job. So we have to sensitize entire team, marketing and your IT teams.
Yeah. So
I think that's important. So we have to read the mainstream media along the way. So we can discuss further when it comes to the Regulation 30.
Require two department to track the media, and also to the communication should be the spokesperson only, and it's strictly no one else. That is the only thing which each listed company should follow. Only spokesperson of the company should discuss and put or communicate on behalf of the company.
Yeah, it's well challenging.
Exactly. That is a strictly. Yeah, sorry. First only we have discussed too much.
New regulation 1A has been inserted after regulation 6, where any vacancy in the office of the compliance officer of the listed entity needs to be filled at the earliest and not later than 3 months from the date of such vacancy. Earlier, there were no timelines specified as to the appointment of a compliance officer, and now a specific timeline has been provided through this amendment. Further, it also specifies that any appointment of interim compliance officer shall be made in the manner similar to the appointment of a compliance officer. So this will now restrain companies from adopting the practice of appointing their KMPs or any other employee as interim compliance officer till the time they appoint a proper compliance officer.
So, sir, I have an observation here. So, like normally at a senior level, if you are appointing a company secretary, it takes at least, so all those senior level people has a minimum 3 months notice period. So by the time, somebody resigns and the HR department starts searching for it, so it takes minimum, 3 to 6 months, and sometimes it goes up to 1 year. Yeah.
I think there's a question.
Yeah, there is a can MD be appointed as interim compliance officer, even if he is not a CS?
If he fulfills the criteria as per law, then yes, otherwise no.
It's very clear, yeah.
Yeah, because in the past we have seen actually some of the companies have been nominating interim compliance officer as their CFO. That has been seen, because I have seen in the site.
Yeah.
So and, that has been the practice.
There is question generally the KMP has 3 months period. How this is going to be done? Or it is really difficult. Panelists,
Dipti, there is no question if it is going to be done. The person, he resigned, he gives the 3 months notice at the such you have a 3 months, so you have to do your best and get it complete. That's all. Compliance is compliance.
Yeah.
I think earlier there was no mention in LODR about the timeline, and the ComapniesAct was complied within 6 months. You have to.
At the company law, it was 6 months.
Now
they
it
made
is
it
just
in 3 months for the listed companies. One has to comply. There is no other goal, Dipti.
Yeah.
Because the day a compliance officer resigns, you have to start hunting the person.
Yeah, that's what. So earlier the companies were doing. That's why they are also saving.
They are taking at their own time, literally.
Own sweet time.
That was the case. But now that is not going to work anymore.
Yeah, that's why they are coming timeline. No sleep. 3 months finished your appointment.
Because they are also aware that normally 2 to 3 months is a notice period for serving the resignation period. So that's why they have come up with this timeline. Please ensure the continuity is there. No gap has to be there.
See, Dipti, the senior position, why the 3 month notice is given? Because the 3 month notice is given to allow the people to locate the successor person and take over it. That is why the 3 month period is actually given. But some other people keep quiet for 3 months, and at the end of the 3 months only they start doing it. So they are not acting time. That's all.
Yeah. Okay, Alifya, next. Please go ahead. Okay, there is a question. Can you elaborate on interim appointment?
I think interim appointment is only when there is a stopgap that somebody is joining little later, and whoever a junior company secretary can be appointed in the interim period. If she or he is a qualified company secretary, then no harm in doing that. You can always replace.
Basically, they cannot appoint a CFO. Normally, sometimes what the companies do, they appoint the CFO. He is a senior person and he can do the job for time being. But or some other person.
No. Normally, what they do in case of the listed entities, till the vacancy is filled up, CFO will act as a compliance officer.
Yeah. So that is now you cannot do that.
That is it. Yeah.
Now you cannot do that because that person is not having the. If CFO is having a qualification of CS membership, then it is fine. But if our CFO is not having the membership of CS, then he cannot fulfill that role.
Yeah, that is right.
Okay. Thanks. Yeah, Alifya.
Further, there have been amendments in Regulation 15(1)A, whereby the compliance by high-value debt-listed entities with the provisions of Regulation 16 to Regulation 27 on the comply or explain basis has been extended up to 31st March 2023, which was earlier till 31st March 2023 has been extended till March 31, 2024. And thereafter, they are required to comply mandatorily. So this earlier, the circular has been issued by the SEBI, which now has been given effect in this amendment.
So I think high value debt listed companies definition is more than 500 crores non-convertible debt securities are outstanding. They should gear up, and so the time is extended further so that they can comply Regulation 16 to 27 also. That's the amendment. I don't think any query or any questions are there.
Right. Yeah, ex-query. Yeah, next.
So a new sub-regulation 17(1)D has been inserted, where with effect from April 1, 2024, the continuation of a director on the board of an entity will require approval of the shareholders once in every 5 years. So this approval shall be subject to approval through special resolution. Further, any director serving on the board without the approval of shareholders for the last 5 years on the date of this notification will require approval within 5 years of this amendment. In the first general meeting to be held after March 31st, sorry, it is meeting to be held after March 31st, 2024. So this is an important amendment whereby a director who is continuing as a result of a right which has been inferred on him through articles of association or a share subscription agreement now will not be able to continue on the board of a listed entity, and he will have to go to the shareholders for his approval every 5 years. Sudhakar sir, any comment on this?
No, I think you can go ahead.
No, I think this is very important amendment. It is talking about there cannot be a permanent seat of the board member. Any member who is, sorry, Sudhakar ji has just come, so maybe he can take it. But I believe it's a non-rotational directors are also there, maybe a senior person who is continuing. And now the amendment has been brought in where now after 31st March 2024, such people who are continuing in past 5 years should be reappointed by the shareholder. And going forward also, it will continue. The shareholders will have the opportunity every 5 years. Yeah, Sudhakar ji, over to you.
Yeah, I agree with you what you say, Amita.
So the problem is
only, primarily there are in some companies, where there are certain, because 1/3 of the directors of the board can be permanent directors. They don't need to retire by rotation. So primarily these people. So primarily this particular amendment is towards them who are having permanent position in the companies, whether they may be promoters or whether they may be other than the promoters, but once in 5 years now, they need to be reappointed.
There is one question that there is a mention of general in this new amendment for seeking shareholders approval. The terminology used general meeting. So if the postal ballot route is not available, mandatory to seek in EGM only.
No, postal ballot is equivalent to general meeting. You can do because
postal ballot will be available. Postal ballot is equal to AGM.
They mentioned like this only general meeting.
But it is
postal ballot can be facilitated.
Postal ballot will work.
Also, there is a law that next round of reappointment for directors, you need to pass through special resolution.
So there is no clarity actually. If you write the SEBI LODR amendments, they are just saying approval of the shareholders will be required. It has not been clarified.
It doesn't say ordinary or special.
Yeah.
But since it is silent, we can presume to be ordinary resolution.
Because wherever they want to be special, they write it very clearly.
They mention it. Here it is silent.
Yes.
So since it is a silent, it should be an ordinary resolution.
Ordinary.
Yeah, and there are other questions, but other next slides will clarify all that question. Yeah. Which all director included is covered.
I think go with the provisions.
It is in the next exclusion. Yeah, Alifya.
Further, this regulation and this requirement of appointment shall not be applicable to the whole-time director, managing directors, managers, independent directors, or a director who is retiring by rotation as per the Companies Act. So their appointment is they are always subject to appointment within 5 years of their appointment or reappointment. So they are outside the purview of this new amendment. Further, any director appointed pursuant to an order of the court or a tribunal or a nominee director of the government of a financial regulator. Further, any director nominated by a financial institution are also outside the purview of this amendment.
So I think the proviso is very clear.
Yeah, it is very.
Any questions are there? Then we can take
No,
up. But
I think it's not there. These are.
Yeah.
Go next.
You can clarify on the vacancy for the due to expiry of the term and already company has filled in that expiry, or company is otherwise also in compliance about the composition of the board, then there is no need, or it will not be treated as a non-compliance.
Yeah, I think it is covered in the slide somewhere. Yeah, go ahead, sorry.
Yes. Sub-regulation 1E has been inserted, which provides that any vacancy in the office of the director shall be filled at the earliest or in not later than 3 months from the date of such vacancy. Further, the proviso also provides that if the listed entity is non-compliant pursuant to the composition of the board of directors due to the expiration of this term of office, then the resulting vacancy shall be filled by on or before the date of such office vacation. If the listed entity complies with the composition of the board of directors, then this sub-regulation will not be applicable to it. Shall I move ahead? Any questions or clarifications from the panelists?
No, go ahead. There is one question. If the board has 6 directors and one of them has resigned, then what should be the timeline for appointment?
Three months,
So it has to be filled within 3 months.
3 months. The 3 months is there.
If you don't
filling of it is 3 months. Filling of casual vacancy means appointment by board or shareholders.
No, casual vacancy is also any time appointed by the board only.
By the board to be approved by the
shareholder is the ultimate appointment.
But if the independent director is getting resigned, you are aware that his term is getting over, then you have to be geared up. You can't be giving the opportunity of 3 months. If the casual vacancy for other directors, I think that's board can appoint and reappoint it in the annual general or the general meeting.
Yeah. Okay. Next, Alifya.
Hello.
A new regulation 26A has been inserted, which provides for vacancies in respect of certain key managerial persons. Any vacancy in the office of CEO, MD, WTD or manager shall be filled by the entity at the earliest and not later than 3 months. Further, here also any appointment of a person in the interim capacity shall be made in a manner similar to fresh appointment as per the applicable laws. This regulation also brings under its purview the appointment of a CFO within 3 months of the vacancy in his office.
So basically,
earlier
it was 6 months. Now they have shortened the timeline for the CFO 3 months from 6 months.
So earlier there were no timelines provided.
Yeah. For MD, it was not provided. For MD, this was not at all. And so they have also exemplified the scope and extended to MD position also.
Yes. A new clause 27(2)(ba) has been inserted, which provides for details of cybersecurity incidents or breaches or loss of data, which shall be disclosed to the stock exchanges through corporate governance report, which is filed by any entity to the stock exchanges within 21 days from the end of each quarter. So every listed entity will have to disclose to the exchanges the details of any cybersecurity threat that it may have faced in the previous quarter. This amendment has been brought in lines with newer technology which is now in place, as the data breach is very common for a listed entity.
I think the rationale behind this is we are thinking that as a country, we are going under the digitization. So any such kind of data loss, data information of cybersecurity breaches are very important. And already the RBI has provided for the banks, IRD has provided for the insurance sector. So the SEBI has also come out that the incident should be reported to the stock exchanges and public at large. But I think there is no format, so it has to be attached to the corporate governance report of quarterly within 21 days. But we as a internalizing, like in the department, you have to inform all your IT department people also to give us data immediately as soon as there is a breach. That sensitization has increased after this amendment. A lot of internal work, I think, there has to be scoped up by the company secretary with various departments. One of them is a cybersecurity reporting, how it will be reported, what way it has to be reported, and what kind of a data breach, a minor data breach, major data breach, all, I think that has to, it slowly, it will evolve over the time.
Madam, isn't it the material event which is disclosed anyways, and why separately is this required?
No, there could be a separate breaches and data loss. It may not be reported if it is not material. And that's the reason the materiality concept is there or not. Anything or everything cyber breaches to be reported, that time will come, and maybe the SEBI may come up with the format, because this implementation will be from 13 July 24 onwards. So the next quarter onward, there will be a reporting. Before that, definitely, I think a lot of clarity will come.
Okay, thank you.
There is a question whether they define cyber security. No, at present, no.
No, it is not defined.
Further, clause C under regulation 34(1) has been substituted with this. So regulation 34(1) provides for declaration of material events, disclosures of material events to the stock exchanges. Now a proper criteria, a quantifiable criteria has been provided through this amendment, where omission of an event or information whose value or the expected income in terms of value to the listed entity exceeds the lower of the following: 2% of the turnover as per the last audited consolidated financials, 2% of the net worth as per the last audited consolidated financial statements, or 5% of the average of absolute value of profit or loss after tax of the last 3 audited consolidated financial statements. So this introduces a significant advancement in the materiality disclosure requirements by a listed entity by providing a proper quantifiable threshold.
So
further, it should be noted
materiality and what we are telling, it's very well clarified. Yeah, go ahead.
I think the threshold what is mentioned, no, it's a enterprise-wise, it's a consolidated.
Yeah, enterprise-based.
It's not for the standalone.
Yeah. And even
Alifya
has already said that for your material subsidiaries also, if any such events are taking place, you need to report for your material subsidiaries also.
First time it is a quantifiable. Now, as a percentage-wise, it was made easy for the employees also what is to be reported, what is not to be reported. The clarity has come. Yeah.
So many questions are relating to the absolute value. I can see in the chat box.
I was coming to that. What is absolute value? Then there is a question that if there is a negative
loss,
what is absolute value better we take?
So it would not be set off if some company is having loss in any particular year among those 3 years. So it would be added, absolute value to be added.
So the negative there was question about no profit also you answered. There is, does the materiality threshold have to be same for statutory auditors while auditing? I don't know what means auditing.
No, for auditing, there is a separate materiality.
Separate, I know. This is for our compliance.
This is for the disclosure purpose.
Yeah. Okay. Negative net worth, you have answered that, absolute.
So like, I think Varika, can you give a, Varika can give you an example. If in the 3 years there is 1 crore, 1 crore and minus 3 crore. So you add 1 and minus 3 again. Like we calculate, it cannot be considered as a 0.
It would be 5. 1 plus 1 plus 3, it would be 5.
No, if it is in minus, it's in a negative.
Minus,
so we have to take the only number. That's what they are saying, absolute.
Yeah. So minus 3 or negative cannot consider as a 0.
Yeah.
But you have to take the absolute number. That's the meaning of this provision.
Yeah. The same question was that by Mr. Amit Chaurasia. The answer is given. We have covered this.
It is a stark contrast. Even if we see any other provision of the LODR or Companies Act, so whenever the loss is there, it is netted off. But this is in a very stark contrast to all of the provisions. You have to add it.
Yeah, even minus.
You have to just take the number.
Yeah. Yeah, Alifya.
Yeah, we can move on, I think.
Further, subclause D has been inserted, which was already in point C. Now that has been shifted to point D, which provides for an event or information may be treated as material if, in the opinion of the board of the listed entity, that event is considered to be material. So here the choice is given to the board to consider the materiality of an event and accordingly disclose it to the exchanges.
No, Alifya, it says even if it is not material, thresholds are not touched, but the board is of the opinion that it is material, then board can intimate and disclose the matter.
Like it could
disregard
be
of your
if company has been rated or if company has been had got some award, so that has no materiality threshold. But if the board decides kind of the award we should anyways notify to the public, so then those kind of instances I would seek in my mind wherein we can disclose without touching the materiality threshold.
So even in current date, when this notification will be considered, I mean, effective from 13 July 23, during this period also, whatever materiality is there, you have to intimate within 30 days. So that 30 days time period starts immediately.
So here there's a catch, I would say, because it is saying any continuing event or information. So from which period I need to start? My company is listed for 20 years. So
no, if your event is continuing, Varika, if the event is continuing and on 30th July 23, you still feel that this event is material and is touching the threshold as an enterprise total consolidated value, because earlier it was not quantified. Now it has been quantified.
Yeah,
if
it,
then the 30 days starts from 13th July onwards.
So
that will be your views.
Yeah, I also agree. And that was the question, that what is material on the date of when the amendment is effective, and if it is not disclosed earlier, same should be disclosed.
Yeah, so that I'm agreeing. My question is, what will be your initiation date? Because it is saying any continuing event as on 30th June. But what period I need to consider? How back I need to go?
Any project which is continuing, any information or event which you feel it is continuing, and the material which is touching the threshold, which is now been provided 2%, 2% and 5%, then you have to intimate within 30 days.
So a company has to identify any ongoing material event, and if it touches the thresholds, breaches the thresholds, then it has to disclose accordingly to the exchange.
And if it has not been disclosed earlier, it is time to disclose again. I mean, it has to be disclosed now.
I agree with you, Amita. In fact, that is what the outcome of this amendment is. All the continuing events you have to, what's called as the shortlist, and then you have to, wherever disclosures are required, you have to disclose it.
There is a pointing that the cutoff date is 14 June and not 13 July.
Yeah, correct. Cutoff date.
Yeah, that is right. That is right.
That is right.
That is right.
Okay.
No, notification is on 14 July, but if my applicability is only from 13 July, naturally my 30 days starts from 13 July.
Correct.
It cannot be from
After
14 June.
Yes.
Yeah, because this particular
It is
provision,
from
if
the
it
date
started...
of coming into effect of the regulations.
Yes, not from the date of notification, effective date. Though it is mentioned the accordance with the notification of this amendment, in the notification itself, it mentioned that the date is applicability starts from 13 July, 30 days after, then your 30 days period starts from 13 July, not from 14 June.
They have themselves clarified, so it's okay.
Yeah, and one more topic we can discuss now, whether we have to change the materiality, determination of materiality policy or not. Is it optional, but ideally recommended as and when you feel that there's a board meeting happening and you are ready, you should change the materiality policy to cover this threshold so that your employees are well aware, informed, and it will help them. That's the suggestion, though it is not mandatory, it is optional completely.
Right.
Yes. So a new proviso has been inserted in Regulation 34, which states that a policy for determination of materiality shall be taken up by the listed entity. And it shall provide for the thresholds which have been introduced for 34. So it has been recommended, but however, it also provides that it shall not dilute any requirement specified under the provisions of this regulations. So even you have a policy for determination of materiality, the materiality thresholds are applicable to the listed entity effective 30th July.
It doesn't mandate that you have to change, but if you're changing, you have to be careful that it should not dilute the threshold.
Provisions, yes.
Yeah.
And further, it shall also provide for measures for the employees to identify material events and accordingly bring it to the authority, to the authorized KMPs, so that necessary disclosures are made to the exchanges.
There is a question. So we can wait.
Yeah, you can wait for the materiality
materiality even after 14 July if we have board meeting post 14 July.
Yeah. There is no bar, no nothing. And somebody has asked whether it can be passed by the circular resolution. It can be, but ideally always the board discuss about the materiality. And so it is no bar as such.
Yeah, that is right.
The question on relevant employee is there. What is relevant employee?
Relevant who has been authorized by the board to take care of the disclosure. So ideally a compliance officer.
Yeah.
Any authorized KMP. The mention is authorized KMP word, so it can be anybody.
How will the KMP determine relevant employee?
Company can authorize its CEO, CFO, or any CTO to take care of the disclosure. Mostly it is, most of the time I believe it is compliance officer and the CFO. It's a practice. I think it is not mandated anywhere. It's company's choice.
Okay, Alifya.
Somebody has asked policies for everyone, then why Ankur? He said then 11 employees targeted. Nobody is targeted.
Not targeting. I have not taken that because...
No, we have to just clarify that it is just to assist that he should reach out to the relevant officer about this threshold. So it is quantifiable. Earlier it was not quantified. Now it has been quantified. So anybody who is authorized can report to the right person.
Okay, thank you. Yeah.
So sub-regulation 6 has been...
Somebody is asking, do we need to disclose ongoing material events only now or after July 13th only? Or can it be done now?
I think even if you do
now, we can start doing now only. That is the better. Otherwise, we need to disclose after the within the 30 days period by 13th of August.
Yeah, we stated that if it is not disclosed earlier, then later you after.
Yeah, so we can start revealing
now also.
No, I think what he must be saying is now if I disclose again, I have to disclose after 13 July or not. So Sudhakarji, once it is disclosed, I mean it is a disclosure, but mandatory, the effective date starts from 13 July. If there is a change in continuing your event or information, again you have to disclose further if there is a change. If no change, yeah.
Legally, you are obligated to inform, as you rightly said, after 13th July. But voluntarily, if you want to disclose it as on date, as a good governance measure, you can always do that. But at the same point of time, if they again on 14th July, you have to see what exactly is the position. And then you have to go for disclosure accordingly. Say, for example, today you might be thinking, okay, I will disclose voluntarily. Since I am doing it, I will do a part disclosure. You may be able to do that. But after 14th July, 13th July, you will not be able to do that.
Shall I move on?
Yeah, please go ahead.
Sub-regulation 6 has been substituted by the following. The listed entity shall disclose to the exchanges all events which are material, and specified timelines for such reporting have now been provided. 30 minutes from the closure of the meeting of the board of directors, whether decision of that event has been taken. 12 hours from the occurrence of the event, in case the event emanates from that listed entity itself, and 24 hours from the occurrence of the event where the event is not emanating from within the listed entity. So now specified timelines have been provided by this amendment, which for disclosure of the materiality of an event.
Somebody has mentioned when to report the appointment of director in the board meeting. But I think appointment of director is not material. Here we are talking about the disclosure timeline where it is the event or information are material. So 30 minutes from the closure of the board meeting, whatever decision which is material, that has to be disclosed. And one more question, I think, Dipti, I'll take up that 12 hours applicable also for the weekend national holidays, or just mentioning the same in reason will enough that it was a holiday. I think it has to be disclosed within 12 hours of the occurrence. Disregard of your holidays or Saturday, Sunday. Yeah.
Working hours not mentioned. It says 12 hours, no working hours. But it's a very pathetic kind of development.
No, but if it is emanating within the organization, then organization is aware. So for the outside, if it is emanating, then you are given 24 hours. So I think 12 hours is reasonable to disseminate all the information to public at large. The purpose or the rationale behind also we must keep in our minds that why the disclosure is so important.
Yeah. Even what happens within the organization, because you are not governing each and every decision. So there could be a decision by some other and which constitutes a material as per the SEBI LODR regulations. So by the time it is coming to the company secretary.
So I think as a good governance, Varika, I will say that you have to sensitize entire department, all the department.
But people tend to forget because they are not doing on a sensitization because sensitization has to be on a continuous basis. The ways people tend to forget because it is not their subject matter, and that's the culture has to be built out, and it will also take in the initial time it would be having the nuisance value because people are not used to doing this. Over a period of time,
any new change will have some pushback, but like POSH, how sensitization is so important in everybody.
Yeah, so but Amita, POSH is for so long. That's how this rigor has come into place. Because POSH is
put that way, now CS has to learn many things and keep on teaching all the employees many things. Yeah. So they will pick you as a teacher also. People has come to teach us.
As a senior management, the senior management has to be first.
Right. Continuously you learn and you also answer. And there is a request that can you please give some examples of event or information emanating from within the system. 2-3 people has requested.
Varika, you will be the right person. What kind of emanating within the organization? It could be many things, but I think you may be the right person working in a company.
Yeah, so emanating within the organization, I would say let's have business contract. Okay, so if a company has got a business contract, so that is emanating within the company because company is taking the action item and that business contract is so material that it touching the threshold. So that is kind of the information emanating within the company. Emanating outside of the company could be any award given by or whatever, or it could be any litigation per se, which is a material. So litigation. So if somebody has filed a suit against the company, which could affect the continuity of the business. So it is again emanating within the company only, because company gets a notice from the court or any regulatory body, or from any kind of, or it could be like a some ED has sent because of a very material FEMA compliance. So these kind of information are emanating within the company only, because regulatory body doesn't sets to the only company, and only company and regulatory body are aware. So these are the information which are emanating within the company.
Further, it also provides that when these disclosures are not made within the timeline specified, then the entity has to provide an explanation for such delay. So a proper justifiable reason also has to be provided to the exchange regarding delay.
There are a few questions, Dipti.
If company is about to sign a contract which depends upon the certain events, whether the same also need to be disclosed considering it is a material?
Sorry, what is the question? If company is about to sign a contract
which depends upon happening or non-happening of some event, so then also we need to disclose considering it as a material?
Yeah, that is under the PIT regulation, I think, whether it is confidential information or insider trading. But I think your signing of the contract would be the event. It cannot be just in. I think again I lost the question, but Varika, you correct me.
Yeah, I think so. Yeah, what they're trying to say is agreement is signed, but the closure of the agreement or the implementation of the agreement is subject to the certain conditions, which are normally put into the agreement. This agreement will be closed subject to the completion of these conditions. Some conditions are precedent and some conditions are post signing of the agreement. So if those post conditions are not met out within a period of time, that agreement would fall through.
No, they're not talking about the concedent precedent. He's saying the happening of the event. And I believe the contract is not yet signed. If the contract is not yet signed, then it is not an information or event.
No, not yet signed means that the event has not occurred.
Yeah.
The trigger point is only when sign the contract.
Correct.
That is the trigger point. Then whatever the conditions, etc., you can always inform them. Any changes later on, that also you can inform. But about to sign the contract doesn't trigger anything.
So condition precedent and condition subsequent are part of the contract, but if the contract is not executed, the event doesn't occur.
Yeah, because we can think of so many things unless and until it is getting into a shape of a definitive agreement, on which basis I am going to report to the stock exchange.
Correct.
It will be misleading.
See, it all depends upon at what stage your discussions and negotiations are. Signing a contract might be only you are sealing it, that's it. But otherwise, sometimes it may so happen you are in an advanced stage of negotiations and almost you have finalized everything. So that point of time, actually, see, the moment if that comes outside, it is going to have a materiality effect. So it is the board which has to decide at what stage it has to inform. No doubt about it. Somebody may also argue that when I'm signing it, then only I'm sealing it. But sometimes it may so happen, even if you sign it out, but that execution of that will come, as Varika, you rightly said that, on happening of certain events. So that point of time, what happens is you have to have a comprehensive communication you have to give to exchanges, stating that this particular that agreement, whatever you have signed, is subject to certain what's called as the events to happen. That's how it is to be done.
But Sudhakar ji, the germination of information, or I mean the germination of that for the insider trading regulation, that is different in year 30.
I agree with you. I'm not disputing that at all. I'm not disputing that at all, Amita. As I was mentioning to you, certain things, if you see the regulation 30 and schedule 3, if you read it together, in part A, para A as well as para B, over and above that, what the regulation says is if the board feels that it is a material information is to be shared, it can share that thing. Even if before signing it, also it can share the information. That's what I'm trying to say.
Yeah, but it is very
we can narrate that it is the company board, they decide materiality and the constructive nature of the event. because they are only executing, they are knowing, and it's on you. They are trying to define and give you the meaning, but it is you who have to decide whether it is today material or not.
So even they will ask you, what is your opinion? How do you feel about it? Because you have to guide them.
Yeah, so in turn, yeah, as Sudhakar has mentioned, it should be informed by the board also that because the decision is taken by them.
Yeah, I think better to inform unless and until you feel some.
Yeah, and whether it
should
should
be in a job party because of the competition factor.
That is one of the reasons why the regulations have put the onus on the board. Apart from your para A and para B, the regulations have find that let us also put some onus on the board. Let them take the call. What is the materiality and when to disclose that particular thing? Okay, because see, these days, the media is so active, they will extract the information from you and they will definitely publish it. So sometimes the board has to take a call that before somebody leaks the information, let me come out boldly. Signing is only, signing of the agreements is only a kind of, sometimes a formality. No doubt about it, it is having a legal sanctity. But to a large extent, sometimes it may so happen that signing is nothing but a formality. Everything else has been decided and everything else is in place. So that point of time, the board has to take a call, and it is always advisable to take a call to intimate the exchanges. On that point of time, you can say that, that these are all in the almost the negotiations have been filed and the agreement is about to be signed. You can disclose like that.
I think the board will be very much into the question mark. I mean, they have to be very carefully take a call because it may.
Yes, you are right. You are right.
It may turn out that the tomorrow agreement is not signed, and there will be question. There may be question that they purposefully done because of the. I mean, for the price.
As I told you, Amita, give a comprehensive information. Don't give a half-baked information.
Yeah, correct.
Okay? Yeah.
Disclosure has to be comprehensive
because the trading window has to be closed. Sorry, I'm just bringing that point that information, the trading window can be closed for such a sensitive material contract. But if I disclose, no, sir, my question is if I disclose, then tomorrow if the things are not worked out, agreement is not signed, the owners will be on the board to prove that it was not through misguide or leading to the price sensitive information or something like that. So,
Amita, I told you that when the board is taking an onus of intimating the exchanges, it should not take a casual call. It has to take a serious call.
Exactly. That's what I'm saying.
That's why I'm saying that when you are taking a call to intimate the exchanges, that point of time, you have to intimate the exchanges in a very transparent way. You cannot say that we have done this, and this is yet to be done.
I'm also the same opinion. I'm reiterating what you are saying, that it has to be done very mindfully by the board.
Yes. That's what I'm saying. Our board with such a good composition has to apply mind, otherwise they're all neck is in a problem.
No, in PIT regulation, you can close the window, but in disclosure of information, they have to be very mindful. I'm just saying to the public generally. Internally, I'm with you what you are saying, sir. Exactly the same thing. I'm also.
PIT for the limited person.
Let's go to next. Yeah.
Somebody has written hostile acquisitions such as Mindtree by L&T would have to be informed while evaluating such deals.
Many things are there this way for signed, unsigned contract acquisition, whether before, after IBC application is filed, whether the same should be informed. Because insolvency application.
I think even nowadays also people when as regards IBC, even if creditors are filing or whatever, because it's available on the NCLT website. So it's better to disclose because nothing you can hide.
Yeah, and it is a very serious impact on the credentials
on the credentials, correct. So it's better to disclose, I would say, from IBC perspective.
It is a big impact, it turn the table anytime. So it should be. That is my also opinion. Yeah.
If it is touching the threshold, definitely. And the question is whether it is emanating outside or inside. I think once somebody is filing, it is outside, but internally also you know that you have defaulted. And the notice is given unless it is a financial creditor. But I think a disclosure is required. Yeah, Alifya. Go ahead.
Yeah. to the existing sub-regulation 11, a new proviso has been inserted, which provides that the top 100 listed entities with effect from October 1, 2023, and thereafter top 250 listed entities with effect from April 1, 2024, shall confirm, deny, or clarify any event reported in the mainstream media which indicates the rumors about an impending specific material event. Reasonably possible, as soon as reasonably possible, and not later than 24 hours. So here the mainstream media plays an important role where any rumor is being published in that. And when such entity confirms the existence of such material event, which is rumored in the mainstream media, then it has also to disclose to the exchange the current stage of that event or information.
I think earlier the option was given, company can remain silent. It may. But now it is, the onus is on the company, top 100 and slowly top 250, and then later to every company that they have to report, they have to give confirmation, deny, or clarify. So somebody has put the question, if they are not aware of the rumor, what? So as soon as I think that question, Sudhakar ji can take up that rumors are not being made aware, from there the denial or clarification will start. But my understanding is that company should have deployed the resources to find what are the rumors which are generating, because now in the fast era of digitization, what we are seeing, all social media, it will be spread like a fire and everybody comes to know. So there will not be much chance that rumors are not being aware of. But Sudhakar ji, what's your view for the rumors?
It also depends upon the size of the company. Also, if it is a very small listed company, if it says I was not aware of this, still some benefit of doubt the exchanges may give to them. But like say, for example, the large companies like Reliance and all, and if they say no, I was not aware of this, nobody believes that. As you rightly said, Amita, that listed companies have to establish their own ways and means to get this kind of thing done. And especially the medium size as well as the large listed companies, they have to keep the things in place. As we have a saying that ignorance of law is not excusable. So similarly here also, but if you say these kind of lame excuses, nobody will buy that. You need to have your systems in place to come.
That is right. Mechanism has to be
and that's why they have said that top 100 listed companies first to start with. And second phase, the top 250 listed companies. That's what I say, that in fact, these are all large companies. They have to have systems in place. They cannot take this lame excuse, I was not aware of. Nobody will buy that. It's not applicable to every company. This is applicable to only top 250 listed companies.
There is a question whether any event reported is required to be clarity, or events prescribed in Schedule 3 only need to be clarified.
Any rumors.
Any rumor.
Yeah.
But it is a two-way sword, because sometimes company, it may be in such a stage that it is very sensitive. So company will be in a dilemma to deny, confirm, or clarify. So it has to be tactfully taken care of by the board and by the officers, because this puts a burden on the board and entire organization how to communicate to the stock exchanges, how to clarify.
See, earlier, Amita, that when you say tactful, earlier what we used to say was by that as per the company policy, we don't react to the rumors and all. No more these companies can do like that. You have to say that whether you confirm it or you deny it, whatever it is, either way. You cannot say, I won't comment about this thing. No comments will not do for this top 250 listed companies.
But sometimes it is very sensitive. If I am entering into some transaction and I say, clarify that no, I'm sorry, then your potential investor may get affected. I mean, it has to be replied very tactfully now. That's what I mean.
Correct. No doubt about it. See, that means what? See, that what in case of a listed companies, they have determined the size of the company also. This particular compliance is to be done by the top 250 listed companies. They cannot put everything under the carpet and the says of by sensitivity or this is very confidential, this is very this thing, that thing and all. Ultimately the objective of this, to some extent, the objective of these amendments is also to raise the bar of corporate governance. So you have to disseminate the information. You cannot keep everything under the wraps. Okay.
Yeah.
Correct.
So I would here just would have a discussion on a point, though it is so if there is any transaction, a good transaction can happen at a subsidiary level. So whether it is also captures that?
Yes. If it is going to impact, if it is, I mean, material to the listed company, yes.
Yeah, it is. Materiality has to be analyzed. If it is going to be material to the listed company, yes, it will be.
I think now it is enterprise level, no? So if it is affecting your threshold, quantifiable.
No, I'm not discussing I'm only this particular topic. Only in case of this particular extent. If your subsidiary is doing it, then also you need to be clarified. That's what I'm saying.
Even your associate also, if it is impacting your quantifiable threshold, then also it is important. Not only your material subsidiary. That's my understanding.
Not only that, even the rumors also. If suppose there is a rumor about your subsidiary company, you can't keep quiet. Say, for example, Reliance case, you take that Jio is a subsidiary company of Reliance. Retail, there are a lot of subsidiaries are there. Suppose tomorrow there are some rumors about those companies. Can you say that this is not about the listed entity? No, it is not so. So even your subsidiaries, about that also, if there are certain rumors are there, which is going to have materiality effect as far as the listed entity, you are supposed to comment about it. I mean, either you deny or you clarify or you confirm, whatever it is.
Sudhakar, here I have a diversion. So that is fine. If it is my kind of wholly owned subsidiary, or if I'm holding a substantial stake in the subsidiary, let's say 80-85%, but sometimes there could be two partners. I'm holding 51. That's it, being a subsidiary, but the other one substantial partner is holding up 49%. Okay, so there could be a conflicting opinion on the subsidiary matter. How
see, Varika, it is like this, even if you are 51 and he is 49, and both are listed companies, suppose, and both have that materiality concept, and both may have to inform sometimes, because that 51-49 is only a numerical. But that particular information may be material to both the listed companies, and both have to inform the exchanges that time.
No, that's what
when that kind of a situation arises, they should intimate the exchanges in alignment.
Because I have seen sometimes what happens, I am a listed partner, okay, but my other partner in a subsidiary level, that is of a unlisted, or it is a foreign body. So that foreign body says, look, I don't want to look into these kind of rigors. That's what are the challenges what we are being facing.
There are challenges, Varika. It's very tactfully you have to clarify. There are challenges because you cannot disturb your ongoing contract, and it's
contract. That's what I'm saying.
And you are not very sure whether it's
two listed entities are there. Yeah, two listed entities are there. Both of them understand that regime. But if a other party on the other side of the table is not a listed entity, it's a foreign body or whatever. So then there are the challenges in these implementation and disclosure.
I think we have to close. There is a challenges, and it was always when there is a proximal acquisition and the company is there.
Yeah, that's what.
Always there, and when the expansion, diversification, every time it's always a challenge. That when it was always a topic of the discussion. But I think with that it is subjective. We'll move to next slide now.
Yeah, sure.
Thanks.
Somebody has nicely, I think Nagesh has mentioned it's a corporate lawyer's delight. Absolutely, how to draft, how to clarify. It's a
law firms come into play.
You have to clarify very tactfully.
This is again a very burdensome. Any communication, it's very violent. Any communication.
No, if it is material.
Any communication is okay, but it is material.
Let Alifya just read that and then we take it there. Alifya?
Yes. A new subregulation 13 has been inserted after the existing subregulation 12, which provides that the receipt of a communication from any regulatory, statutory, enforcement or judicial authority by a listed entity shall be disclosed to the exchanges unless such communication is prohibited by the authority itself. So the receipt of communication are the words which are open for wider interpretation.
Yeah, but as I and Amita has pointed out that it is for the material event, if any communication, because if there is a materiality, then reporting. So as regards that, whatever communication from regulatory, statutory enforcement has to be informed.
Yeah, that is right.
So if there is a fire broke out and certain people died and you give some notices or kind of thing or claim and all that, that is a communication. Even though it is starting, you have to mention that.
No, because even in the starting of the word, it says, in case of the event or information required to be disclosed. So that means the materiality is to be seen. Not any communication.
Yeah. Panel, please, if any comment they want to give. Otherwise, we'll move. Okay. If a company receives notice for fine for non-compliance of LODR, whether it need to disclose.
That will come. It is part in the Schedule 3.
Yeah.
Part para B optional, but I think it without.
Yeah, letter.
That will come, I think, in the slide.
Yeah,
Alifya
subsequent slide. Yeah.
Yes.
Yeah, Alifya. Can we move to next slide, panel?
Yeah, please.
Yeah.
A new regulation 30A has been inserted after the existing regulation 30, which provides for disclosure requirements for certain type of agreements binding on the listed entities. So any agreement entered by the shareholders, promoters, promoter group entities, related parties, directors, KMPs, or employees of a listed entity, its holding companies, subsidiaries, and associate companies, pertaining to any agreement specified in clause 5A of para A of part A of schedule 3, such agreements have to be informed to the listed entities within 2 working days of entering into such agreements. So now the onus is on the agreements which are binding or are having an impact. Clause 5A provides that any agreements which has an impact on the listed entity or on the management of the listed entity, for which the listed entity may not be necessarily a party to that agreement. So such agreements have to be informed within 2 working days.
I think this is very important, 30A, because this covers a lot of earlier agreement also, whichever is subsisting agreement also, along with the notification, you have to pick up all the salient features and put it in the web link and disclose in your annual report for 22-23 or 23-24. And this read with 5A, it also mentions all such agreement where the listed entity is not a party, but it is affecting 3 thresholds. Either it is for the purpose and effect, directly, indirectly, changing or managing the control of the listed entity. Second is if it is imposing any restriction. And the third, if it is creating any liability on the listed entity, the stockholders, the shareholders should be made aware of. So these disclosures are very much required. In the consultation paper, it was mentioned about the approval plus disclosure. Fortunately, the approval is not required now. It is just a disclosure. You have to disclose all your existing past many years shareholders agreement, which is continuing, is also given a link into the annual report. So I think this is a big task on the compliance department to be geared up for the annual report when 22-23 also.
Yes, so these agreements will be a part of the corporate governance part of the annual report. So there's an important task for each company, even for this financial year.
And the rationale in the consultation paper also was mentioned that anything you are changing, the party who is involved, who is getting impacted, should be aware of at least. Earlier they mentioned they should be getting the approval also, but now fortunately it is to be aware for, and that's very relevant and right. I think this is a good move, but maybe a burdensome for the employee company secretaries also. Sudhakar ji, any view on this?
Yeah, here also I said again the same thing. Earlier what used to happen, say for example, there may be, even in case of listed companies also, there may be JV partners are there. And they used to have some kind of an understanding among themselves with respect to the company. And the company is not a party to that. And all the other shareholders who are there, they have no clue about this kind of an understanding. So those kind of contracts have to be now be intimated to the, rather disseminated to the public. And similarly, say, for example, you are getting a technology, there is some technical collaboration agreements out there, and they may be imposing some restrictions as far as your marketing is concerned, as far as your territories are concerned and all. Again, the same thing, that the company is not a party to that sometimes, but still these kind of restrictions are there. So I go back to the earlier the purpose of the amendments to some extent is to raise the bar of corporate governance and to bring the transparency into this thing. Okay.
I think somebody has put the question whether MOU are considered as an agreement, but I believe MOU can be terminated. Agreement are a full, completed. You have to see the MOU. The name is not relevant. How the clauses follow in the name of MOU, you are still continuing and agreeing into the definitive agreement. Then whatever name it is an agreement, and you have to disclose.
Correct. See, MOU, you cannot say it is not a binding agreement and all. Yes. By merely writing that, you cannot say. MOU is also an understanding between two parties. So it may be, if any kind of a materiality is there, even at the writing of MOU also, you can have to mention it. But that time, don't say that you have entered into an agreement. You say entered into an MOU. And when that MOU collapses, again, you intimate the exchanges. But when to do that? That is the board's onus again. They have to see that am I serious about the things? Is going to take place? Or it is just in the thin air?
Non-binding term sheets are different, but MOU in the garb of agreement, you are just putting the name as MOU, but all the terms are definitive. Then the onus is on the board to disclose it. Somebody has put some example. Pratibha is asking to put some example of such kind of a shareholders agreement, which I believe Sudhakar ji has already given.
In fact, I have seen one MOU wherein it said that in case this MOU falls for any reason, so-and-so has to compensate so-and-so with this much amount. What is that? That is material, definitely, because they are having an understanding definitely to go ahead with that. For whatever the reasons, if it is going to fall, then one party has to compensate the other party. That is definitely having a material this thing, and you have to disclose that kind of MOUs. So MOU, legally, whatever the status may be, but as far as the intimation to the exchanges are concerned, you have to see that at what stage you are entering into the MOU. At the very inception stages or very advanced stages. So it is the onus of the board which has to take a call whether to intimate or not to intimate.
I think legally
and everything you cannot put into the regulation what to do, what not to do. This is actually this is left to the professionals. That is where we are coming into picture.
I think this question should not arrive. This question cannot arise as whether it's an MOU or agreement. If legally you see some MOUs without consideration, also it has some imposition of some certain restriction, it becomes an agreement. So that legality Shaban should see. Yeah, Dipti.
In various forum, SEBI, this question is asked when even the contract, MOU, contract yet to be signed. And they are just answering that you are the people who know that whether you want to follow that. And whether you are serious, you are going to take action. No one else except you. So if you decide whether it is going to be there or not, disclose. And if then we argue that whether this can, because it can be negative, is it fine? That's why it is understood that, and you can give explanation. So then you are justified rather than not telling and trying to justify, but telling and justify why it is not happened. So it is best you judges are there, whether it is there or not. So either KMP and that, as I mentioned, that if KMP is not decision maker, better take a clarification whether it is to be followed and it is going to be material. Because always KMP cannot take a call themselves, but has to take it. So this was the given. So it's a very subjective matter, honestly. And we have only to take call. They are telling, we ask clarification from regulatory, and regulatory said you are only the decision maker, not we. That way they answers. Okay, I think we can go next panel.
Yeah, you can go. Life is going to be very difficult for the working company secretaries when it comes to implementation.
Yeah.
Sir, nothing like it. Let me tell you, when Section 90, the significant beneficial owner thing has come, people used to say that now everybody is comfortable. This kind of unpleasantness may be there for a few days. After that, jisko jo karna hai, wo to karte rahenge.
No, that is right. But the thing is, he has to bring the awareness and create the thing, the other people, because he has depend upon getting the information from the others.
Yeah,
that is where the problem comes.
Key lies in the sensitizing the other departments.
Yeah, that is
because they're saying why we should be so bothered, what harm it can. So there is a key challenge in.
Yeah, that is the biggest challenge for him. That's it.
Yeah.
Apart from all the things, one thing is very clear: the company secretary now, at least, he cannot work in isolation. He has to work together with all the departments, and similarly, all the departments have to cooperate with the company secretary.
Yeah.
This kind of awareness is to be created at the board level. The company secretary should not mince words. He has to explain to the board very clearly what kind of a role the board is having, what kind of a role the company secretary is having, towards which the entire organization, wherever it is required, they have to cooperate not on a charity basis, but on a statutory basis.
Yeah, that is true. But
it should be mandatory.
Yeah, that is true. But the company secretary need to have the better board support in this matter. Otherwise, things will be difficult.
Sudhakar, just to clarify, many people are asking what kind of agreement, lease agreement or any kind of agreement. So just sum up, I think this agreement you have to read along with the para number 5A in the Schedule 3, Part A, Paragraph A, which says only those agreements which directly, indirectly is put or potentially affecting or the purpose or effect is to impact the management and control of the listed entity, or put an impact or impose any kind of a restriction on such entity, or create any liability. So you have to see this yardstick also. And then who has entered into the agreement, not only the shareholder, but it also talks about shareholders, promoter group entities, all the related parties of the director or the related party, directors, KMP, and the employee of not only my listed entity, but my subsidiary associate companies. All those agreements which has the impact or purpose for impacting this thing need to be disclosed. So it widens. Somebody has to work out completely and sensitize entire related parties also, that if you are entering any kind of an agreement which will have some restriction on me, it has to be disclosed by my board. So again, when the related party provision has come in, we have prepared the chart. Similarly, here also we have to prepare an entire chart, who are covered, what kind of agreement they are entering into, and if the purpose and effect is this 3, I have to disclose. So it will be initially, it will be Herculean task, but then slowly it will be a part of your corporate governance practice. Yeah, sorry. So some answers are given, which are on the chat box about the lease agreement.
Basically, rightly mentioned, and earlier also, this all provision is giving position to the CS as a chief compliance head, and that's why connect to each and every department and each major event that should be known to CS. That is getting, crystallized. Yeah, Alifya, go ahead.
I'll go ahead. Oh.
Yeah.
So a new regulation 31B has been inserted, which provides that any special right granted to the shareholders shall now require approval of the shareholders in the general meeting by way of special resolution once in every 5 years, starting from the date of grant of such a special right. So any special right given to the shareholders by articles of association or any subscription agreement entered into will now require approval every 5 years. Further, it also provides that any rights which are already available to the shareholders at the time of this amendment coming into force shall be approved by the shareholders by way of special resolution within a period of 5 years from this regulation taking effect. Further, this regulation will not be applicable to rights given to financial institution or a debenture trustee. Any comments on this, panelist?
I think it is very clear. Can go ahead. Or still, panelist, if anyone wants to comment.
Somebody has put the question, any example of special rights? So I think right to appoint a director, or maybe affirmative vote of your major investors may be allowed. So such kind of a special right, you have to, company has to actually after this notification have to have a to-do list, what is required immediately, what is required in next 5 years. So this kind of an special right approval is required by special resolution.
In fact, yesterday somebody asked me a question that the superior rights shares are there in the listed companies, and whether superior right shares, whether they fall under this particular regulation now, special rights to shareholders. To my knowledge, no. Superior right shares, when you are issuing, you already had the approval of the shareholders.
Yes.
And superior right shares you issue only to the promoters of the company. So hence again, special right shareholders, the approval of the shareholders and all is not required once again.
Yeah, thanks for this clarification. Yes.
If the company provides special right to CCD holders, which can be used after the conversion of CCD, is the company needs to take approval from shareholders, or will it be covered in exemption list?
No, you need to cover, because that's a CCD's exam. CCD is internal. It's not a financial institution. The exemptions are carved out only for two. For all those listed, I mean, the lending institution, which are financial institution, and for the debenture trustee who are registered with SEBI. CCD are maybe a private investor, and you have to consider that as a special right which they are holding. It has to be approved by within 5 years.
Okay. Alifya, next.
A new clause J has been inserted in Regulation 33(3), where it provides disclosures to be made by newly listed entities subsequent to their listing. The submission of financial results by them has to be done to the exchanges as per the timeline specified. So for immediately, the timeline specified are either within the 45 days or 60 days or within 21 days of their listing, whichever is later. So for example, if a listed entity gets listed in the month of October, 31st October or so, then it has to accordingly submit its financial results to the stock exchange 21 days after October. So it will be 21st November.
I think it is, the time is given to them. So suppose somebody is listed on say 13th August and they have given already in their prospectus up to 31st March result. So they have to cover April, May, June, and they are getting listed only on 15th August or 14th August. They will have only 1 day to disclose, because that has to be disclosed within 45 days. So then they are given 21 more days. Disregard of that 45 days is on 15th August for the closure of that quarter's report to be given. So that's a liberty, or that's a relaxation given to such newly listed companies. There are some question around it, or I don't know. Somebody.
Same as the case with the financial year closing also.
Yes. Yeah. Yeah.
Somebody is saying we are going towards a simplification of the law, but complicating it for amendments.
No, sir. It is for the benefit of the public also.
This
is a global practice. These are all global practice which we are slowly implementing over a period of time. It's not suddenly. It's overdue, I believe.
The question is whether it is applicable to SME listing also.
Every listed company.
Every listed company.
I move on to the next regulation which has been substituted. So regulation 34(2)F has been substituted with the following. The top 1,000 entities have to submit a BRSR report in the format specified by the board from time to time. Proviso has been inserted which provides for the disclosure of assurance of the BRSR core shall also be obtained and submitted to the exchanges as per the format and in the manner specified by the board from time to time. Further, the entities shall also make disclosures and obtain assurance as per the BRSR core for their value chains. So here the clarification will be provided by the board for the disclosures to be made by the listed entities. Sudhakar sir, any description of the BRSR core that you may...
No. See, BRSR report is different to that of BRSR score. BRSR core is some kind of a ratios and all which the SEBI is yet to specify. Okay.
Bring about.
So yeah, bring about. And then the format also, you know. So as far as on date, we have no clue about what is BRSR core as such.
I think in the consultation paper, it is mentioned that it is a key performance indicator. So KPIs will come up.
Correct.
KPIs will be specified for each company. And due to the ESG reporting, this framework has been mandated now.
So you have to, that time you have to furnish BRSR report as well as BRSR core also.
And not only for the company, but its value chain also over a period of time. So the phase of implementation maybe slowly SEBI will come up.
Widely, yes.
Yeah, because a small company might have the infrastructure also to get through this kind of reporting.
It's applicable to top 1,000 companies, no? So it's not for the small companies. But the supply chain may be very small company, and there the implementation of ESG or governance or
that's what I'm saying.
Reporting would be difficult for them. So for the value chain, it is still not. SEBI has given the power that they will specify time and everything. Yeah, Alifya.
Yes. Further, the listed entities not falling under this criteria may also voluntarily disclose BRSR and obtain the assurance of the BRSR code for themselves and their value chains. A new regulation 37A has been inserted.
Somebody asked, one second.
Yes,
Mr. Kaushik has asked, assurance of BRSR means any certificate? No, it's not a third party assurance. It is a company, as per the KPIs, they have to assure that they have the core that they will publish separately. What is the value chain? That's the supply chain, or from whom you are taking your vendors. That's one more question. One more is Amita Tiwari. Is there some other format for voluntary reporting of BRSR? So far not mandated, but I think you can pick up the BRSR mandatory for top 1,000 companies and you can specify. I think that's it. Yeah, you can go ahead.
New regulation 37A has been inserted by this amendment, which provides for sale or disposal of an undertaking outside the scheme of arrangement. So here a listed entity carrying out the sale, lease or disposal of the whole or substantially the whole of the undertaking shall be required to take the approval of the shareholders, prior approval of the shareholders by way of special resolution. Further, it shall also be required to disclose the object and commercial rationale for carrying out such sale, lease or disposal and the use of the promoter such sale. Such a special resolution shall be treated as passed only if the votes cast by the public shareholders in favor of the resolution exceeds the vote cast by public shareholders against the resolution. So this is an important amendment or insertion which has been brought about by this regulation.
I think this is very, very critical and very important approval required, a prior approval before you pass on or you carve out and division to be separately sold out to your wholly owned subsidiary under the exemption route, and tomorrow the wholly owned subsidiary also transfer to third party. So this way you cannot transfer your undertaking, and undertaking meaning same as per section 181A of the Companies Act, but only problem or only I see a challenge here that the prior approval of shareholders by way of special resolution to be taken, but in the explanatory statement, you have to give the objective and use of proceeds. Till that, I have no problem there. Objective, why I am selling, and use of proceeds where I will deploy the funds. But the commercial rationale to be given to the shareholder, I am finding little too onerous on the company, because the board of directors know that what is the rationale and commercial wisdom should come from them, not on the end. And apart from that, the public shareholder only can vote. They cannot vote. So here I see little something, maybe in the next seminar or something, we can find out some more challenging.
Basically, here you require dual approval. One is a special resolution, and second one is the majority of minority shareholders. Yes. So both the things have to be there. Then only you will be able to implement this decision.
Correct. That's the reason the commercial rationale to be given. And there also, I as a board member or the promoters can't vote, but the decision they are taking. Suppose I have a plant and it's not doing well, and I want to give away that plant to somebody. Then you have to ask and put before the shareholders the objective and the use of proceeds, okay. But the commercial rationale, it should be left to the board of directors. Not do the shareholder, well, minority will decide on the majority. That's,
No,
I think I'm finding it challenging here.
No, 1 minute. See, it is not like that. What happened whenever you are disposing any undertaking. Okay, so earlier what happened was it was at the whims and fancies of the promoters only or major shareholders only. Now, what here they say is by that even the minority also should have a say on that. For that particular purpose, you have to give the full details why you are disposing of that undertaking. What is the reason for that, and what are the commercials, and what that ultimately your utilization of the commercials. So, because in the past, what used to happen was some kind of a companies, what they used to do was they used to dispose of the undertakings, and after that, siphoning of the funds also. Several companies, it has taken place like that, and the minority shareholders have no say on that. And in fact, I don't want to take the name of that particular person, that there was one industrialist at one point of time. This thing is only one thing. Cash-rich companies just take over that, strip the companies, and after that, just exit out of it. So they were industrialists like that. They were business people like that. This particular amendment which has come is towards that particular purpose only. You cannot just dispose of the undertaking at your whims and fancies. You have to establish the rationale for that. And you can participate in the decision whilst passing the special resolution. But at the same point of time, you also need to have another approval, that is majority of the minority.
No, but sir, here the special resolution, you cannot take the party. I am okay. I understand that to loop the loophole. To plug the loophole, I am understanding. But it says the special resolution is required to be acted upon only the vote cast by the public shareholders in favor is more than, and you cannot participate. Either you are directly, indirectly.
Correct. So what I am trying to say is, in the special resolution, you can participate as a promoter. But when you are passing that other resolution at the passing of the majority of the minority, you cannot pass it. This is a dual approval you require. At one point of time, they want to bring this concept even for the appointment of independent directors also, but subsequently it was dropped.
No, but here there is no dual appointment. That's only special resolution, prior special resolution where they cannot vote. So it's a single. It's not a dual approval. You cannot vote directly, indirectly. If you are interested, it is only minority. That's a challenge which I'm finding. I'm saying, okay, if I'm also allowed in the dual responsibility or a dual resolution passing, but here it's a single resolution, prior approval, special resolution where interested parties cannot vote. So it is a minority who will be taking a decision. That's a question mark. That's what I'm highlighting, how it will be reacted.
There, this is there, Amita. You see, if you see the wording, provided that such a special resolution shall be acted upon only if the votes cast by the public shareholders in favor of the resolution exceed the votes cast by such public shareholders against the resolution. That means what? In the special resolution,
no, furtherly, no public shareholder shall vote on such resolution if he is a party directly, indirectly in such transaction.
That is public shareholders, See, you have to read this very comprehensively, Amita.
Yeah, okay.
Special resolution, promoters can participate, right? But in that special resolution, you can act upon only when the majority of the minority also have voted upon. So you have to see, first of all, how the special resolution was passed or not. Okay, special resolution is passed. Now eliminate the shares of the what's called as other than the public. Then in that remaining portion, you have to see the majority of the minority have approved it or not. Then only you can act upon the special resolution. In that majority of the minority, when you are doing it, if any public shareholder is directly or indirectly interested, his votes also to be eliminated. That is how this is to be worked out.
So you mean that the promoter can vote definitely in that?
Yes, certainly. The special resolution, he can vote. Special resolution, he can vote. But that special resolution is, you can act upon only when that majority of the minority approves that. That's why I said that it is a dual approval which is required.
I think this needs some more clarification, because if he's interested in the subsidiary company.
Hello, Mr. Sudhakar, this is P.K. Rastogi. Good afternoon.
Yes, hi, good afternoon. Good afternoon, Mr. Rastogi. Rastogi is a very senior person and from the JK group. For the benefit of the participants. Yes, Mr. Rastogi, glad that you are attending this.
No, of course. Thank you very much for organizing such a wonderful and timely seminar. the point which is being discussed, I also agree with Anita Desai ji that one special resolution is required. There are two requirements in it. One, that it has to be a special resolution. Now, within that special resolution, we have to see whether votes cast in favor of the resolution by the minority shareholders is more than the votes cast against the resolution by the minority shareholders. So within the special resolution, you have to see two things. One, that it has to be a special resolution. Another one, that votes must be more by the minority shareholders in favor than the votes cast by the minority shareholders against it. So I think I go by the interpretation of Anita ji.
That is what precisely I am saying, that Amita is actually going against that. Amita is not clear about that.
No, sir. Exactly what Mr. Pavanji is saying. I am saying the same thing. Single resolution required of the minority shareholder, public shareholder.
I also said the same thing.
Sir, you are saying dual resolution required. So dual
approval required, not dual resolution.
Yeah, but dual.
Two elements of it. That's what Sudhakar is saying. Two elements to it.
Yes.
When a special resolution.
Amita, if you are the scrutinizer, okay. Now I will tell you, you are the scrutinizer of the, suppose, a company. This particular resolution has come. How you have to see that? First and foremost thing is, okay, special resolution is passed or not passed. Okay. Wherein the promoter will be a party to that. After that, you have to see that second approval is there or not there. What is that second approval? Because that special resolution, which was approved by the shareholders, you can act upon only when the majority of the minority is approving that. For which, what you have to do? You have to eliminate the shares of the shareholders other than public category. You eliminate that. Then you see in that elimination, whatever the portion is left out of that, the majority has to approve that resolution. If they approve upon, then only the special resolution can act upon, otherwise not. Third aspect to that is, when you are arriving at that public shareholding, the majority of the minority, that point of time, if anybody in the public also directly or indirectly interested in the resolution, he is also to be eliminated along with the promoters. That is how this particular resolution is to be. Only one resolution. I am not saying.
I'm not coming to the process. Process may be same, but ultimately the outcome would be, it can be acted upon only the minority is approving. And so correct. I'm saying the commercial wisdom or the commercial rationale has to be decided and acted upon. That transaction can be acted upon only if the minority is voting. And that's the challenging which I'm finding. I'm not going to the process of dual approval. Ultimately, what is the outcome is minority is.
I am trying to explain the objective of this amendment. Objective of this amendment is to curb the practices which were prevailing, fortunately or unfortunately, at certain quarters. That is to be eliminated. Now it cannot happen. Earlier, what used to happen was the minority has no say on that, whatever was happening. This, especially the disposal of undertakings.
No.
Now it cannot happen.
Mr. Sudhakar, for the benefit of participants, I may inform that this is the kind of requirement which in the previous company that we used to have for approving the scheme of arrangement or merger demerger, where there has to be a resolution, but simultaneously we have to see whether people present in the meeting have passed, whether the majority of the people present and voting is also there.
Correct.
So it is the same kind of requirement now.
More or less kind. Yes, more or less like that.
Right. Thank you.
Yeah, thank you, sir.
Sir, this is Amit Chaurasia. I have one question. I'm
yes,
from JK.
Oh, you are also there. Good, Amit. Amit is also from JK Group.
Yeah. So, sir, I just wanted to know that normally when we pass a resolution under section 181C and 1A for increasing, for taking the borrowing limits, which is more than paid up capital and fee reserve. So, company generally also pass a resolution under section 181A for allowing to create mortgage in favor of the banks. So, even that resolution will be attracted by this regulation 37A, or is it actually at the time of selling of the undertaking?
It is at the selling of the undertaking. Sale, lease, or 1 minute, Amit. You have to see the wording here in 37A. what the resolution you are passing under 180, 1A or 1C, whatever it is, that is for the purpose of Companies Act. If your company is a listed company, you have to comply with both Companies Act as well as listing regulations also. And as far as that particular resolution, what you are passing is for the purpose of sale, lease, or disposal of an undertaking. Okay. That point of time, you have to, pass in the way this what's called Regulation 37A is getting amended.
Because the disposal is interpreted as like creation of a moderator is also a disposal.
Amit, yesterday we discussed this and we were also of the same view which Mr. Sudhakar has just clarified. That for passing the resolution under 181A, you do not require to go through this specific requirement of having the 12 criteria. It is a simple resolution as it is standing today. So nothing new as far as 181A is concerned. Mr. Sudhakar has also clarified. Yesterday we discussed in our group company meetings and we were also of the same group.
I'll request panelists, both Amita and Sudhakar, if you can close, if I understand. The difference is whether that this resolution, everyone will vote or the promoter cannot vote. The view is that it can everyone vote, but the action will be taken only if public shareholders voted for is more than voted against. Difference of view is there, but I think the things will come up. The views
No, there is no difference. That's what we understand, that everybody,
okay,
but it cannot be acted upon. Process is same. Process is what Sudhakar ji said, but it can be acted upon only when the minority
right,
is.
Fine. Then we are agreeing on.
Thank you.
Thank you. Let's go ahead. Let's go ahead because many slides are there. Then you will skip that.
I think 1 minute, Dipti. Atul bhai, 1 minute leta hu main. Atul bhai, 1 minute leta hu main. Should we continue or should we take a break? Because see, a lot of important things are there even now. It will take another 1 hour minimum. If you are really discussing that.
So I have a suggestion, sir. I have a suggestion. So that's what I'm just coming for. I think, so this is all, something which is new, which is going to happen. And there are so many if and buts, so we can probably, instead of, restricting our deliberations, say 1 hour or half an hour, I think that let's have a part 2 also. And probably those questions, which has been raised, we can even take it up in the next session.
Next Saturday. Everyone is hungry.
So Dipti, I think, these are all things, which are changing, and changing for I don't know, for a better or for the, so more concurrence for the employee company secretaries, so, somebody has to understand the effect also. So, so I think, my suggestion probably we can continue for another 5-10 minutes and then part 2, we can, we can take it up in the next Saturday.
See,
that's what my suggestion.
So just allow to complete 37A. And then
So let us complete 37A and give a pause here and we can discuss for some more time about that issues, whatever we have already discussed. Then the remaining portion, we will take it up in the next webinar.
Done, sir.
You can complete.
Okay. Yeah.
Further, this also provides.
Just a minute.
Provides that the regulations, sub-regulation 1 shall not be applicable when such sale or lease or disposal of an undertaking is being made by the listed entity to its wholly owned subsidiary whose accounts are consolidated with it. So, this is an important non-applicability in this provision. Further, where wholly owned subsidiary selling, leasing or disposing of this undertaking received from the listed entity to a third party would again require the listed entity to comply with the requirements provided in sub-regulation 1. So whenever the subsidiary is further selling that undertaking to another third party, the listed entity will have to take prior approval of the shareholders via special resolution. Listed entity shall comply with the requirements of sub-regulation 1 before diluting its shareholding below 100% in its wholly owned subsidiary. This provision shall not be applicable to financial institutions and debenture trust.
I think the exemption is carved out. You can transfer to your wholly owned subsidiary without going to the special resolution. But then later on, your wholly owned subsidiary should not pass on to the third party. And if they are transferring that undertaking to third party, you again, listed entity should go back to the shareholders and get the approval. But this may not be remain. I mean, it will be again a prior approval
Amita,
before the wholly owned subsidiary transfer. Yeah, sir.
If you see the word, provided further that the listed entity shall comply with the requirements specified in sub-regulation 1 before diluting its shareholding below 100%. Means even if you want to sell a single share.
Single share, yes. I was about to come to there. Yeah. So there are two provisions. One is the wholly owned subsidiary selling. Second is you diluting a single share. In both the provision, you have to go to the prior approval of the shareholders before the transaction. Yeah, I think 37A is very, we need some more time to understand.
Yeah, 37 is very, it's a kind of, because any of the loophole they have plugged in.
Yeah.
Only thing is, Amita, according to me, 37, there is no ambiguity or interpretational challenges, but the only thing is practical challenges are there.
Yeah, absolutely. It's not a legal challenge. I agree with you. You are talking about the process. I was also saying the same thing, that effect cannot be, the transaction cannot be acted upon. So we are on the same page, but in a different way. The challenge will be practically, some companies may find where the minority will be a decision maker and the rationale they will not understand for doing the transaction. Maybe sometime.
See, Amita, what I do is, my objective is always, whenever we discuss, in fact, in future also, Amita, whenever you make any presentations, first and foremost thing is, as company secretaries, we have to have the legal clarity. As far as the practical challenges are concerned, though our responsibility is there, it is not completely our responsibility. Our responsibility is towards the legal challenges. So our clarity as far as the legalities are concerned, that should be more. Once it is in place, yes, no doubt about it, that how to get the majority or minority and all those things. It is just like your related party transactions. It is nothing new. It is already there. Even in case of related party transactions, what happens? It is a majority or minority only. Wherever the promoters are there, they cannot vote upon. The related parties cannot vote upon.
Right.
So I don't think it is a very major challenge, but according to me, I am very happy as far as 37A is concerned, because I have seen several times in front of our eyes, several gullible promoters were stripping the companies and the minority shareholders couldn't do anything, even the regulators also. Now, wo sab tamasha band ho jayega.
No, sir, the major scams are due to this related party transaction and passing of the subsidiary, and then thereby the passing of your major chunk to the outsiders. I understand it completely plugging all the loopholes. It is good. At the same time, there are some challenges in the explanatory statement where the commercial wisdom to be put, commercial rationality to be put is a new thing which I was highlighting. But then we went into the in the voting part, that how and who. But I think we are on the same page. I agree what you are saying. So, legally, I am with you.
So Amita, there as a practitioner, you will get more business. Varika will come to you how to draft this particular.
That's what I'm thinking.
On the lighter side, I'm saying that
the PCS,
as a practitioner, you will get more business.
Sir, yesterday we discussed that with Varika, that there are so many challenges to sensitize the board and the internal, all the department, where the PCS are ready with the presentation to highlight that how you have to sensitize. Like a POSH committee, we all have presented. Similarly, new changes, definitely PCS has to be involved. But I think that's on the lighter side again. Thanks, Sudhakarji, but we are on the same page. I'm not against you, or we are not have a contradictory view. We are having the similar view. I was not talking about the process, but ultimately the outcome was, I was talking to that it cannot be approved.
So there is a question, what if wholly owned subsidiary board does not consult listed holding company before selling undertaking? Is selling of investment in SPV considered as sale of undertaking?
But wholly owned subsidiary board will be totally governed by the wholly owned subsidiary only, the listed entity.
Company. It means you are a decision maker over there.
Yeah.
Okay.
The selling of investment.
General resolution passed under 181A, but by the shareholders. Do we need prior approval again in case of mortgage, hypothecation, or pledges?
No.
No.
So, Sudhakarji, I have one question. Why the JV is not included? In many places, it's a subsidiary, wholly owned subsidiary only. But the JV, I mean, that was a question also of some of the participants in the previous slide.
In the JVs, what you can do with when it is your subsidiary, you cannot do the same thing with your JV because there is already other party is there. They will resist. You cannot do that simply at the JVs. That's why.
Similarly, for the subsidiary also, there could be another party. They are mentioning subsidiaries and the wholly owned subsidiaries, but not JV. That's a question.
Maybe to some extent, JVs may be subsidiaries also.
Yeah, that's what I said earlier also. If there are the two participants who are more equivalent to like 51-49, or it could be 3. If 3 are there, so it is a JV kind of a stuff. Then it has a more because it talks about the subsidiary.
Basically, where you have decisive power yourself, you are in a position to take the decision. So then it is you will ask the others. Means you solo alone don't take decision. If your company is JV and you have power to decide that portion of your JV to set, means majority are there and you can take a decision. There you involve your public servant. That way, yeah, go ahead.
I think let us take a pause here, Dipti, that as we discussed it, and then next week.
Okay. Thanks, everyone. There are certain questions also, but we'll take a pause. If anything left or questions, we'll dig out and we'll again attend this in the next session, which will happen on next Saturday.
I have a small suggestion. Next Saturday is the meeting of Secretarial Standard Board, which I will be joining for the first time. So I will not have the benefit of joining you. Anyway, I wish you all the best.
I know Mr. Sudhakar will also be not there. He is also there in the meeting, right, Sudhakar?
Yeah, correct. And of course, Amita and Varika are very well equipped to take care of that, even if I am not there, not an issue at all. And Rastogi, you can see that you can watch the recording subsequently.
Right. And I will have the benefit of meeting you on the coming Saturday in any case. So you are coming to Delhi.
Certainly.
Very good.
Okay.
Thank you, everyone. Thank you, Mehta and Mehta.
It
was very nice topic, relevant topic.
Thank you, and Atul.
Thank you.
Thank you.
Thank you, Varika. Thank you, Amita. Thanks.
Thank you.
Everyone join next week. Thanks.
Thanks a lot, Amita. My special thanks to you for the preparation. You put it very, very nicely, very aptly, giving the things and analysis. It was very good. Wonderful job you have done. My special appreciation to you. Thanks a lot to Amita and Varika for your excellent support and your sharing the knowledge. Really, it's very good. And as we have seen, our participation has gone nearly closer to 400. Yes. That itself shows what is the importance, what is the thing. In fact, in the chat box, if you have seen, somebody has already passed a resolution for you. Unanimously passed a resolution for you, giving appreciation to Mehta and Mehta team for organizing such a seminar.
Thank you, sir. Thank you,
Mr. Malik. Thank you.
Yeah, it's really a nice platform which the Dipti and Mehta, Mr. Mehta are doing for the profession.
Yeah, it's all our professional colleague discussion only on the platform. Very elegant.
Varika, you'll be glad to know we already crossed 100 webinars. It is, I think, 103rd or 104th.
We will do it. Okay.
Thank you. Bye-bye.
Thanks a lot to everybody.
Thank you.
Thank you.
Thank you, Mehta. Thank you.
Bye.
Have a nice
Thanks,
day.
everyone.